Okay, so I will try to make this presentation. I'm going to run a little bit and to provide more general ideas instead of going through every detail that I have initially planned, so that we have some time for discussion and to compare the approaches. The idea here, the main idea that I would like um, to show about the Brazilian approach is that we departed. Initially we had a very similar approach to the European AI Act, and then we gradually incorporated different aspects to reach an approach we can call a Brazilian approach, which has important difference, although the main core of the European AI Act is still preserved in the Brazilian approach. So our approach was strongly inspired by the EU AI Act. The first thing to mention is that there is sectoral regulation of AI in Brazil. And this is important because in the legislative debate in Brazil, this was an important source of pressure for modification of the so-called, now I'm calling Brazilian AI Act, from its original version. So there is regulation on AI and the applications of AI into the courts by the National Council of Justice. There is a regulation by the central bank, mainly focused on credit scoring and credit risk systems. There is a regulation in the health sector by the health agency, which is focused on the regulation and registration of software as a medical device. And there is also a regulation by the electoral authority, which is the Superior Court of Elections, and which regulates the use of AI for publicity in elections, and particularly addresses the problem of deep fakes. So these are important areas of AI application that usually, as Georg has shown, relates to high-risk applications. And that there is already rules regarding the responsible use and deployment of AI systems, and particularly to protect rights of affected persons.
Juliano, we still see, we don't see the presentation mode, and we still see the first slide. So if you intended to move on to other slides, and maybe you can do the presentation.
I think that the best thing to do is to minimize here, and then can you see it properly? Okay, so we'll move in this with this mode of presentation. Okay, so these are the sectoral rulings on AI that are already in force. Actually, the Brazilian regulation on the Brazilian courts, the National Court regulation, is under revision now. I'm a member of the commission that's revising the regulation 332 by the National Court of Justice, and the motivation to change this ruling and to revise it is the upcoming of generative AI. So in order to adapt to the challenges brought about by generative AI and the use of generative AI by judges, the regulation is being... I started saying that the discussion started in 2020. There was a first proposal approved in the urgent track in less than 1 year in the Chamber of Deputies, which was quite general, with only with abstract values and principles on responsible AI, and delegating the regulation to public organs and regulatory agencies. Something like the US approach with just directives in the federal level, and then regulation specific in states and regulatory agencies. Then in 2021, the bill went to the Senate, and the Senate has organized a committee of jurists. I was part of this committee to evaluate the Chamber of Deputies proposal and then provide elements or propose a new draft bill in making additions to the original one. But then the result of this debate was actually a new bill that was proposed as a new one by the Senate. This has some legislative implications, but what is important is that the approach changed completely. It became a document much closer to the AUAI Act. Then after that, the Senate created a temporary AI commission in August of this year. And then the bill is undergoing a lot of changes. That's why I said metamorphosis, incorporation, several different elements that I'm going just to give you, provide you an overview. So actually, the bill is, as I said, influenced by the AUAI Act. So it's based on a risk management systems for high-risk AI with some procedures for governance, which are quite close to the AUAI Act. And if we want to classify, I have this axis where we can see whether the regulation is mainly external or internal, or whether the governance requirements are transversal or are sectoral. So the US approach, as I said, it's similar to that first approach by the Chamber of Deputies in Brazil. So it's a main directive delegating power for sectoral regulation. The and with an external authority. So it's an external regulation by state, but sectoral in US. In Europe, it's a transversal regulation of standards for that holds for any sector of activities, but it's mainly external with us enforced by a central external authority. And what I have learned from FUMIO today is that Japan followed the view where the regulation is transversal, but applying international standards which are not specific to some sectoral activities, but in general, it's more based on not on mandatory governance procedures, but on internal use of this standard by private companies and developers and deployers of AI. So where is Brazil? The first bill from the Chamber of Deputies, as I said, was similar to the US approach. The second one, much closer to the European AUAI Act. And let me just come back. This is not a mistake. I just put it here. The flag of the European Union is a little bit below because there are instruments of internal regulation, as Georg Borges has shown, right? There are codes of conduct and certification procedures, which are mainly private. So, and then the transition bill, that is under transformation. There were 3 versions already published, and there will probably be, after the elections in this month, there will be a consolidation of the debates with a new bill. But I'm going to talk about the present one. So the original bill proposed by the Commission of Jurists was close to the UAI Act. The basic concern is about product safety, intended to protect fundamental rights
from mainly individual harms. So it's the base and it's the same orientation, and it still holds. Other aspect that still holds is the commitment to transversal governance procedures for risk management for high risk AI systems. It's also based on a risk-based approach, as well as in the European approach. The classification of risks is focused on different types of applications in different areas that are considered sensitive. It's the same in Brazil and still holds this approach. And there is an external central authority for ruling and enforcement of those risk management systems. So this is the core of the European bill, the European Act that was present in the original Brazilian bill, and it is still present in the bill that is under discussion in the Senate. So there was something different from the EU-AI Act from the very beginning in the Brazilian approach, which was a mix of product safety approach with a rights approach. So there was a chapter, a very extensive chapter on rights of those people affected by AI systems that detailed many rights, sometimes in a way which was more detailed than the governance procedures in the chapters about governance, with provision of rights for transparency about use, transparency about criteria and explanation of the criteria for decision making, transparency about the data employed, data protection rights, non-discrimination rights, rights to human revision, and right to challenge the automated decision, but even to challenge predictions or recommendations by AI systems. And these rights are intended to be enforced by law courts. And this was a source of a lot of criticism. The concern here would be with legal certainty regarding that there will be an administrative regulatory agency applying and enforcing the law, and as well as the judiciary will be applying the law for the protection of rights. So this was strongly criticized for the concern with legal certainty. There was also rules on liability with a special regime for the liability regarding AI systems, with strict liability for high risk systems and a rebuttable presumption. This is with an inversion of the burden of proof for all other non-high risk systems. We have observed an evolution. You remember that this ruling, this first proposal in Brazil was made in 2021. So it was before the explosion of generative AI. And so we have observed the legislative discussion in Europe about the adoption and the revisions regarding generative AI. And this has had reflexes in our legislative debate. So the evolution in the EU-AI Act, which can be highlighted, is in the role of, in the list of fundamental rights, it was not only individual harms, but democracy and the rule of law was mentioned, and also environmental protection, which may influence future regulation in Europe. There were then governance rules for general purpose AI, a new category of risk, which was called systemic risk, which is based on size of the model, the volume of data processed. and mainly rules determining transparency by developer of general purpose AI system and risk management rules for the deployment. There was also the introduction of the rights to transparency and explanation for affected persons, and before high risk systems, and some rules on investments and the development of AI, particularly sandbox and support to startups and small companies. Well, what we have observed of changes in the Brazilian then regulation after this debate, after generative AI, after changes in the European AI Act. So within these 3 years of debate in the Senate, we have then observed these changes. There was a revision of the chapter of rights. These rights provisions were very detailed, but then they became more general. The enforcement system has changed a lot in the direction to incorporate more powers to regulatory agencies. So there we had then a balance and more influence from sectorial regulation. So there should be a balance between the central authority and the sectorial regulation. We have introduced more rulings on self-regulation, which could be, for instance, codes of conduct that could be approved by the central authority, and also rules for recognize, acknowledge sectorial and private self-regulatory associations. So we introduced also governance rules for general purpose AI, and then there was these additions, rules, a detailed list of rules for promoting investment on AI, rules on environmental sustainability, and rules on the impact of AI on employment. So let me go very quickly through all these. The chapter of rights was changed. For high risk AI systems, there were only some provisions on transparency about use, data protection, and non-discrimination in a more general, and human supervision in a more general fashion. And for high risk AI systems, more details about the right to explanation, not only for automated decision, but also for predictions and recommendation, and the right to challenge the decision, but also prediction and recommendation. And not only human supervision on the development and deployment, but also the right for human revision. The enforcement system has changed. So it was now in the present bill, there is a system, a national system for AI regulation, which is composed by the central authority, which is the main entity that gathers the main and the most important powers. And it is already indicated that this authority will be the Brazilian Data Protection Authority. It has the power for issue regulations which are transversal and more general, and to enforce those rules. It is the coordinator of the system, and it also validates codes of conduct and is empowered to provide the framework for accrediting and to promote a program of certification of AI system. But there is also empowerments for sectorial authorities, basically regulatory agencies, that already have, as I said, but can adapt the general regulation to specify rules and standards of conduct, and also specific rules or demands of governance or managing systems for specific sectors of economic activities, and to promote sectorially best practices and codes of conduct by private institutions. There is then a permanent council for regulatory cooperation. The main goal of this council is to bring peace to the relations that are potentially conflicting between the central authorities and sectoral authorities. So it's going to coordinate and provide support for the harmonization of these rulings, and is going to promote AI advocacy. That means to promote the values of responsible AI in society and in public administration. And also there is a committee of AI experts to provide expert opinions and advices for the permanent council on AI cooperation, which is called CRIA. And then going through those new changes and modifications of the Brazilian bill, self-regulation was emphasized with a chapter on the conducts of codes of conduct, a chapter on regulated self-regulation where the authority is going to acknowledge self-regulatory entities that are going to provide technical standards and etc. And there is the provision of an accreditation of a certification program and the accreditation of certification entities. For general purpose AI, there are specific governance rules for risk management, which are mainly focused on results, not exactly on procedures as it is for traditional AI systems. But we have not used a new category of systemic risks based on size. So this is different from the European AI Act. Regarding civil liability, the special regime was dropped. So it's only mentioned that the regime will be the general one, which is ruled by the Brazilian Civil Code, which has a proviso for strict liability for a high risk activity. So those applications that may be considered by the discretion of judges as high risk activity would be subject to strict liability. And also there is a deference to the consumer protection regulation, which has also rulings on strict liability to protect consumers and also the inversion of the burden of proof. Investments. There are some rulings on to promote investments and the development of AI. So regulatory sandbox, support to startups and small companies, state investments for public-private partnerships, investment on research that privilege technology autonomy, structure to financing research centers, and also infrastructure for to provide computational power, but only if based on renewable energy. And there are some rules emphasize environmental sustainability, and this is the case because Brazil sees itself, the Brazilian government sees a great potential for Brazil to be a world supplier of green energy for AI. So there is this emphasis that priority should be given to AI systems that enhance energetic efficiency, investments of computational infrastructure based on clean energy, funding research on green AI, and also the provision that should be certification programs to provide certification for AI systems or infrastructures for development of AI that are sustainable. There are also provisions on the impact on employment. Basically, actually, this is not mandatory, but it's some rules that provide directives and enhance public policies to mitigate negative impacts on employment and to promote positive impacts on applications that may be intended to professional development, to protect health of the employees and better work conditions. And this is a polemic issue. I'll spend just a few minutes here. There is a chapter on copyright, and it is deeply influenced by the lobby of traditional media. Traditional media has not the same economic power as before, but it still holds an enormous political influence. So the rulings on copyright are quite protective of authors and the producer of content that is disseminated by the digital media. So what are the main rules? Developers of AI systems must disclose the use of protected work. There should be remuneration and compensation for protected work in the development of AI system. There are rules for this compensation and remuneration. Authors are entitled to forbid the use of their work. There are also rules that deem anti-competitive conducts by developers that may discriminate those authors that forbade the use of AI. And there is a minimality principle. The use of copyrighted work should be done only in the limits which are necessary for reaching the goals of the application, should not have negative impacts in the economic interests of authors, and should not compete with the distribution of the original work. So these are very polemic matters that are still under discussion in international courts and international initiatives and also academic debates. But as you see, the approach is completely biased in the sense of defending authors. And I'm not only myself, but several experts are concerned about how this regulation could compromise the development mainly of generative AI or foundational models in Brazil, because it will be quite difficult to obtain authorization for the use of protected work, to compensate in terms of violation of copyright those authors, and also apply this minimality principle. It will be not easy. So it's completely unbalanced if you check the debate, the academic debate on that, and also the debate that is already put before courts, mainly in US. So this is an overview of the Brazilian approach.